put in place to ensure that?
There's always the appeal from a judgment rendered by a court. That is the fairest method by which a judge-alone trial can be determined. Is if the appeals court determines that the judge did not rule fairly, then the opportunity to overturn that decision is presented to the defendant. But I believe that it has been tried in a number of jurisdictions within the English-speaking world, to include, and I have a list of them here: Jamaica, Cayman Islands, the Turks and Caicos, Belize, Trinidad and Tobago. That's within our region. And then outside of the region, in Australia, Canada, New Zealand, Nigeria, Northern Ireland, the United Kingdom, and of course the United States, all have judge-alone trials. And they can be very efficient because when a jury is empaneled, the lawyers can be very persuasive of jurors. We've seen it in the movies, but outside of the movies, in real life, the lawyers perform for the jury. With a judge, you get less of that because the judge is going to be cognizant of the law and also any breach of the law. But with a jury trial, a lot of emotions and so on can be impacted. Now, I'll tell you a story about the Turks and Caicos, Cayman Islands, and so on, where the Brits still have some administrative control. They were actually planning to move trials by jury out of those jurisdictions, out of the Turks and Caicos, and take the plaintiff and the defendant, or rather the prosecution and the defendant, to another jurisdiction under British rule, because they found that no matter what the evidence or how the evidence pointed to guilt, that very frequently jurors would come back with a not guilty verdict. And they believed it had something to do with the absence of anonymity. In other words, the defendant was likely to be someone who is known by the jurors, or to be related to the jurors, or to have some connection with jurors, and as a consequence, justice was not being served. So there was this ambition to move those jury trials from one jurisdiction to the other, since the law was identical in all of them. But I think that this judge-only trial has brought some sanity to the decision-making, and as a consequence, it's been adopted permanently in those jurisdictions. And I believe it has served its purpose well.
Well, what sort of cases would be tried? Would the defendants have the option to be tried by jury?
Under the trial law that was adopted in Antigua and Barbuda, there are certain cases that could or could not be done by judge only or judge alone. Sexual offenses was one of them. And the defendant, in all other instances, had an opportunity to determine whether he wanted or she wanted a judge-alone trial. And by the way, received whatever he or she may have chosen on the advice, usually, of his lawyer.
So what about, we have so many cases still in remand, would this speed up the justice system?
To give some more efficiency, bring more efficiency to the courts. Because when you have a jury trial, the selection of the jurors, the sitting of the jury and so on, it consumes far more time than when it is judge alone. You know, very frequently, if you've been to the courts, you know that lawyers will ask for a sidebar with the judge, and that means asking the jury to leave for a while, when the two lawyers, the plaintiff's lawyer as well, the state's lawyer, which is usually, in Antigua and Barbuda's case, the DPP, and the defendant's lawyer will argue some matter of law before the judge, and then they call the jury back in. And of course, that delays significantly the length of time that it takes to complete a trial by jury. So we're looking for efficiencies and also for justice. You will note that that a public defender's office has been established so that those defendants who have no money can be represented by some very skillful lawyers employed and paid for by